Hi.
Hi, Adam. So are you also joining the session? Where are you joining the session from?
Sorry?
Where are you joining the session from?
Oh, from Luxembourg.
Ah, okay.
There is a newcomer, I see. A new person joining us.
Yes.
And you are joining us from where?
From Paris.
From Paris, okay. Oh yes, you're working for the UNESCO.
Exactly. How about you? Are you working for?
I'm working for the European Court of Justice.
Oh, okay.
Or to put it more correctly, from an institutional point of view, from the Court of Justice of the European Union, because that is the official name of the court.
Yes.
So yeah. I think I will switch the light on because it's a bit. Well,
True.
it's quite good weather today. But,
It's wonderful weather here today in Paris. I want to jump
yeah.
out, go out of the house.
Provate a vedere se mi sentono.
Good afternoon, can you hear us? And slash, I see you.
Hello.
Perfect.
Hi.
Hi, Stanislas. Can you hear us?
Yes, I can hear you.
Wonderful. Welcome. I see Pratik. Pratik. Great to see you. Hi.
Likewise, great to see you.
Hello, and I see Stefano Nativi.
Hi, nice to see you.
Sorry that indeed I missed you in the list. I had you in the written paper, but then I missed you on the SMS. I'm sorry. So, and we have Giuseppe Buffone. Giuseppe Buffone.
Yeah, good morning. Buongiorno. Now I hear you. Maybe you don't see me.
No, we cannot see you, but we can hear you.
Just a moment. I will try to give an authorization because it's a problem of mine, maybe.
I think there is a bit of echo from the room.
From our room?
Yes.
Yes, indeed.
Okay, so we are going to check that with the technical. Yes, hi, welcome.
Ingrid. Ingrid?
Yeah, she's coming. She just went to see if we can manage.
Yes. It seems to me that the problem might be distance with the microphone. It could be distance with the microphone.
So you think there's too much distance?
Yes, you are maybe a little bit far away. I don't know.
Okay.
You can maybe get closer to us, and it might be easier to.
Can you hear me better? No, is there? It's here. Yes, so no.
I think it was okay. I think Ingrid is a bit far, so that's why Ingrid was not clear. But
Yes.
those of you who are next to the microphone, it's clear.
Yes. Here is it better? Is it better here? Yes.
It's a bit better.
It's a bit okay. That's a pity because we are in another place, in another building, because I think the organizers, they had to organize very quickly because we are the only hybrid group. So,
C'è un po' di eco?
sì, un po' di eco.
Non lo so, ho messo tutto.
Non si riesce a fare.
Non si può mirare perché.
Una prova sono chissà che mettiamo quello del computer, magari entriamo questo qui, che pensi? Se possiamo
No, poi non usate perché ora delle effetti, se poi io stacco quello e poi usate il PC, dovete il PC sul tavolo.
Il PC e poi te lo do io e lo do a te.
Ogni volta con il PC. Sì.
No, non lo so perché
Per loro, sì.
quanto male senti.
Allora, facciamo così, abilitate un microfono voi, io disabilito questo perché è questo che genera eco.
It looks as if we can't hear you at all now.
Yeah, it's true.
I think they are muted. That's the.
Oh, they are muted, huh? Yeah.
Yes.
Hopefully they are muted.
Ciao Stefano.
Ciao Giuseppe, come va? Tutto bene?
Bene, bene.
Sunny day, today.
Bellissimo, infatti. Guarda, secondo me meglio che a Capri. Je pense qu'on peut aussi parler français, non? J'ai écouté que tu es de Paris, non?
Tu parles avec moi?
Ouais.
Oui, je parle français aussi, oui, bien sûr. J'habite à Paris, oui, c'est ça.
C'est ça, j'ai bien écouté. Alors, on est en train de dire qu'il y a un soleil incroyable.
C'est vrai. J'aimerais bien à l'extérieur, hein, franchement.
Et à Paris, c'est comment le temps?
Il fait beau, je crois, c'est vers 20 degrés, pas 20, entre 18.
Il fait magnifique ici à Luxembourg également, il fait superbe.
C'est une belle journée pour aller à Gand, alors, monsieur le professeur.
Mais tout à fait, mais tout à fait. Je sais, on a déjà eu l'occasion de se croiser, Giuseppe?
Oui, oui, je pense que oui, parce qu'il y avait une conférence, quelque chose comme ça, sur le competitive law avec l'université de Gand, et
Ah oui, oui, oui.
j'étais là. Donc, pas comme cours de justice, mais comme professeur.
D'accord, d'accord. Oui, oui, il me
Donc,
semblait bien que tu t'avais déjà rencontré.
So,
Alors?
can you hear us now? Is it better?
Yes.
Yes, it's significantly better. Significantly
Indeed.
better.
Wonderful. So we found a solution with the computers we had. Yeah, apologies. I think it was not easy for the organizers because indeed they are in a wonderful place, Certosa di San Giacomo, which is an historical building. I don't know if the Italian colleagues, maybe they will say a word about it, but it's not so easy with the technical aspects, as you can see. So this is one of the choices we have to make between history, what we have, this wonderful past, and also, yes, the efficiency. So in any case, apologies for this, for being late, also because we were late this morning. We are still waiting for the face-to-face participants because, for example, Raffaele Sabato was supposed to start, but he is on his way. Yes. Okay. And Rosario also is coming.
But it's not so easy.
Yes, and the place is not so easy to find. Yes, I confirm. Yes, indeed, I confirm. So anyway, thank you very much for being with us, even if it's online. We are on a Saturday, so we completely understand the problems also of availability. So at least we will manage to have this session about Europe in this digitalization conference here in Capri. Please come, welcome. So we have also participants who are coming to listen our discussions, and maybe you can accommodate wherever you want. I think also there if you want. Yes, please. Okay, so, and we are calling Raffaele Sabato. As usual, you can guess that we are running after time. So, and we have many distinguished speakers in this. Yes.
You respond?
Yes. Or maybe if you could be, yes, because we are also waiting for the speakers. Stiamo ancora.
I didn't get if you will be there.
Okay, sorry. Thank you. So organizational matters. So we are running after time, I was saying. So I will ask you again to stick with your time. We said it's 8-10 minutes per speaker. So I will try to coordinate you the best, and I will dare, if you don't mind, showing you, making a little sign if you are a little bit late, which can happen, of course. And yes, and from my hand, so I have the pleasure to coordinate this very interesting group, and I switched a little bit the order because we want to find a balance between those who are online and those who are face-to-face, so that we don't forget those who are online and you don't forget us. So again, thank you very much for being here. So for those who I don't know, I'm Ingrid Dervaux. I'm the European Judicial Training Network Secretary General. And I am also a French judge. So here we are talking about digitalization, which is a huge challenge for everybody. And we all know that digitalization is everywhere. It has been everywhere for a while already, and maybe we even don't realize that. I say it for myself also because I remember, and this is something I would like to share with you before we start, a memory that I have, and it was around 6 years ago, I was working as an investigating judge, and I had one of my colleagues receiving sometimes a request of cooperation from his colleagues, from his European colleagues or even worldwide colleagues. And he was telling me, you know, sometimes when I am in trouble with translation, you know what I do? Because I don't speak English or I don't speak other languages, I found a very interesting tool. I put everything in something which is called DeepL. Wonderful. So I put everything in that and it translates, and then I am fine. You know, I don't need anything more, and I can already assess if it is something which requires attention or not. And I was, really? DeepL, what's that? And I find it really interesting. And I started looking at that, and I realized that many of my colleagues, and it was already a while ago, were using this tool. But I didn't know that it was AI. I really didn't know that. And I even did not ask myself the question at that moment. How is it possible? I thought, oh, it's a nice tool. So it's fine. It's fine that indeed we are many of us using or feeling the need or assessing that there is a huge opportunity with digitalization, which is not only AI, which is also very diverse, because with digitalization, we also talk about new tools. We also talk about the digitalization, the cross-border cooperation. So we see that there is definitely an opportunity to increase efficiency, to increase the communication, and to ease our lives, because we are all working with smartphones, with computers, etc. But here I would like to be more specific, because as we are talking about justice, we are, for most of us, judges, prosecutors, court staff, lawyers. What does it mean for a judge, especially? Because indeed, if you are a citizen and you are using new tools, if you are using AI without understanding it well, it might be a danger, but it's your individual responsibility. Why, when you are justice, you have law. And here we know that it is one of the fundamental values of the EU. It's from the Article 2 of the EU. And we know that this is a huge responsibility for all judges, prosecutors, and court staff to uphold the rule of law, to ensure that human rights are guaranteed. And how can you do that if you use a tool you don't understand? If you are not able to understand the digital era where we are already? This is the question. And as a judge, especially, you have a strong responsibility, because, as I said, it's an opportunity to increase transparency, to increase efficiency, and the rule of law is also the sound administration of justice. There is a link, and we made that link last year with a publication I would like to mention as an introduction, because I really would like you to have a look at this publication. Last year, with the EJTN, we organized a forum of judges in Syracuse. So it was already in Italy, and we gathered judges from 25 EU member states. And we discussed about rule of law, but rule of law not as rights. The independence of the judges are not a right for them, not only, but as a duty, because rule of law is also the sound administration of justice. And we connected that already with the digital era where we live. So following the discussions we had with Chatham House Rules, we issued a publication which is related to the sound administration of justice in digital era. And you can find this book easily. It's open access. It's accessible in the EJTN website. But we had especially two panels which were very interesting. It was responsibility of judges through performance, because digitalization means that you have many tools. You have the duty to use these tools if it can help you to ensure or to improve the quality of justice, and also responsibility of judges through transparency. Transparency, because indeed, also with these new tools, with this digital era, we can be more transparent. We can ensure that there is a better access to justice. But there are also threats,
there are also challenges that you must be aware of. And it's not possible to ensure the rule of law, to uphold the rule of law in the digital era we live in now, if we are not aware as justice professionals of the threats, the opportunities, but also the way it works. What is exactly AI? How the tools are built? What is the challenge for the data file? Everything. You must be aware of that as a judge, prosecutor, or court staff, because you have the strong duty to ensure the rule of law. And here we come with training, because indeed, as EJTN, we have the strong asset that we gather all the judicial training institutions in the EU. So we work together to create training activities for all the European judges, prosecutors, and court staff. We put our efforts together, our differences as well, and we manage to create relevant activities. But here is a special challenge, because as I said, digitalization is everywhere. It's very diverse. We are talking about many things. It has been here for a while already, and it will evolve. There are many, many things which are planned already, and there are maybe many evolutions we even don't think of now. So yes, thank you. So now the challenge for us is really to define which trainings will be the most relevant, timely in the future to better accompany what is already there, the digital transition. So we have our members, national judicial training institutions, and this is what we will be doing today. And we share together the national experiences, the national perspectives, because Europe is that. It's all our differences, our richness, because we can also share best practices and we can think together about the future. But we have also many important partners. And here we have the European courts that are represented today. We're still waiting for the Court of Human Rights, but he's coming, I'm sure, he's here. But at least we have also Stanislas Adam, who is representing the Court of Justice of the EU. And we have partners like UNESCO, new partners. I'm very pleased to see Pratik with us. So he will explain also what he does, also with us, EJTN, to create relevant activities which are dedicated to this very important objective, to ensure that in this new era, in this digital era, we manage to equip judges, prosecutors, court staff across Europe with all the knowledge, the know-how, the skills they need to accompany that transition and especially fulfill their task and mission. So it's a huge task. Of course, we will need all our members and partners, because we cannot train all the European judges, prosecutors, and court staff directly. So we will need the multiplier effect. We need also you to disseminate what we are doing and the outcomes of our reflections. So here, I think we could start already with a perspective from the European courts. And as we don't have the European Court of Human Rights represented yet, we could already start with the Court of Justice of the EU, because indeed I know that, and I hope you all know as well, that the Court of Justice of the EU has already worked on this field, and especially on AI. Sometimes it's not so well known what they have done, but Stanislas Adam, who is a référendaire at the cabinet of President Lennart, I'm sure will mention it. And we are lucky to have Stanislas, who is also a strong supporter of the European Judicial Training Network and was also involved in the publication of the book together, and last year in the Forum of Judges. So Stanislas, it's a pleasure to have you. Maybe you could start by saying a few words about the position of the Court of Justice of the EU regarding this new digital era. Where are you? Is the Court of Justice of the
Thank you very much, Ingrid. Can you hear me properly? Yes, I will first try to share my PowerPoint. I think it's the first step. Thank you for that introduction. It will give me the opportunity to get back to some aspects of it, indeed, in my presentation. Let me just try to share that screen with you. Yes, just. Can you see my presentation right now? Sorry, it's not so easy.
No,
Can you see it?
we see your screen, but not your presentation.
Yes, we see your screen, but not the presentation, Stanislas.
Okay, it's trying to. I apologize for that. It's PowerPoint Live, maybe, yeah.
So.
Oh, now it should work.
Yes.
Wonderful. So, do you see the presentation? Okay, perfect.
Yes,
thank you. So, indeed, I wish to emphasize, especially on our AI strategy adopted recently in my presentation, and take that as a starting point to see where we stand indeed in terms of AI and EU justice. And as you know, EU justice covers especially the Court of Justice of the European Union, including the Court and the General Court. But we should also take into account member states' courts, as they are members of the EU judicial system in general. So although they are not formally involved in what we are doing right now, clearly the next steps will be to open discussion with them to develop a coherent approach on all that. So I will first say a few words about the digital transformation of the court, then look into more detail into the strategy itself and the guidelines that were adopted to implement them. And I will then end up saying a few words about the famous or infamous AI Act and its impact on EU justice, with some open questions and future challenges. The digital transformation of the court it has started long ago. And Ingrid, I appreciate the fact that you also mentioned that digitalization is not limited to AI, of course. We have digitization of judicial processes, which have developed at the court for a long time and which are quite advanced. I dare say we are probably one of the most digitized courts in Europe, if not in the world. We have the e-Curia application for lodging any litigation acts, litigation documents. Internally, we have developed the digital file. I started working at the court in 2011, and everything, or almost everything, was still paper at the time. Nowadays, everything is digitalized. We can, of course, print documents, but we have the digital file, which is extremely helpful since it allows you to get access very easily to pending cases or past cases. It limits also the risks of getting access to a case on which you are not supposed to get access. So there are various degrees and levels of access rights. And of course, all that is much easier to manage digitally. We have the Eureka search engine, which is very easy to use. It operates like a Google, and it gives us access not only to case. Can you hear me?
You can.
Okay, because
Your slides are blocked.
Yes.
Yes.
my slides are blocked.
Yes.
They unswap.
Yes. Maybe if you put it as a diaporama, it will work.
But it was as a diaporama. That is what I don't.
Yes.
Can you see it now? It's
Yes.
okay. Let's work like this. So you see now the digital transformation of the CJEU.
Yes.
Okay. So we have the Eureka search engine, as I said, and all that will be merged into the new digital environment of the court, which is called SIGA, and which is to enter into force next year. The Innovation Lab was created in 2019 at the level of the Direction for Technologies and Information. What's important to mention is it collects all information, including externally, on any digitized or digital tools that might be useful for our work. The DTI, the Innovation Lab, is a member of the AI Network Plus and collects information on, for example, new AI models or new AI systems that could be useful for the court. They are screening and appraising its potential relevance for court work. Of course, it is not immediately put into use within the court, and it's subject to experimental analysis within the lab. And that Innovation Lab nourishes, if I may say so, the AI Management Board that was created on the basis of the AI strategy of the court adopted in 2023. The AI Management Board has become our new, let's say, organ, specially in charge of examining and appraising AI tools within the Court of Justice. So let me now say a word about the strategy itself. It was published with the 2023 annual report. Prior to the AI Act, it's noticeable. So we adopted it prior to the AI Act, and it's among the very first AI strategies adopted by a court. Evolutions within the CJEU will be, of course, followed in this respect. We are conscious of the fact that many outside the court, especially national courts, member states courts, are very curious to know what the court is going to develop in this respect. And here I make the link again with the rule of law value, which Ingrid mentioned, the rule of law value, which also requires the member states and the court to work in close cooperation to ensure that the EU judicial system offers efficient protection of the rights conferred upon individuals by EU law. And all that is, of course, requires, of course, not necessarily uniform, homogeneous solutions, but at least coordination and cooperation. So we definitely have to listen to each other when working on those topics. That strategy covers both the judicial pillar of the court, but also the administrative pillar. That is very important to mention because we have the vast majority of employees at the court are working as support staff, not as core people developing the case law itself. But everyone is in fact subject to that AI strategy or concerned by that strategy. I think it's a first point to make. Not only judges or prosecutors should be aware of the advantages and dangers of AI applied to justice, but also support staff, court staff. The CJEU acknowledges the advantages of the AI applied to justice systems. It can increase efficiency For example, by detecting at a very early stage when a new case comes to the court, concepts or legal issues that will connect to existing cases or maybe even pending cases, and this also across the two courts. So maybe a pending case before the General Court might be referred to by the system to the Court of Justice when a reference for a preliminary ruling reaches the court. That would significantly or could significantly help the activities of the Directorate for Research and Documentation, preparing those famous fiches de pré-examen, which indeed are a preparatory document submitted to the reporting judge and the Advocate General in charge of the case when starting examining the case. Speech-to-text algorithms are another very clear example. We very often ask for transcripts to be made of the hearing to make sure that all people involved in dealing with the case, including referendaires, will be able to decipher, to know into every detail what has been said at the hearing. Nowadays, it's still done manually, if you'd like. But we are currently testing a speech-to-text algorithm, multilingual, so which will allow multiple language speeches to be translated or transcripted into one language, French in this case, a transcript very quickly after the hearing. Quality and coherence of judicial decisions, because, for example, if we look into procedural issues such as leaves to intervene, there are so many decisions that are adopted that it is nowadays relatively difficult to make sure that a chamber, for example, within the court, does not adopt a procedural stance which is incompatible or not entirely coherent with what has been done by another chamber at another point in time. Which one is the right one, that I don't know. Maybe the new one wants to take a different approach, and the first one made a mistake. It's possible, but at least what is very important is information, knowing about that. And clearly, artificial intelligence could help us adopt more coherent decisions and thus increase, and that's the third advantage, increase equal access to justice and equality of litigants, and also transparency. We could also increase transparency through transparency on court case law, court procedures, by creating virtual assistants that is mentioned in the AI strategy that could help third parties to know our case law better and procedures better. Of course, as Ingrid also mentioned, as we all know, AI also comes with risks when it comes to judicial activities. I will maybe not mention all of them here, but the clearest seem to me to be unintentional biases indeed. That is the risk of discrimination, because the machine, whilst producing an answer, eliminated certain results or included certain irrelevant results, or abstained from making a distinction which is crucial in order to deliver proper justice or examine a case properly. Disclosure of sensitive data, of course. And here I can mention a very clear example, which we discussed yesterday with one of the persons in charge of all that at the court. We have to be conscious that when we start writing a sentence on DeepL, for example, so a generative AI tool, the machine, the system, the software will train itself, will learn based on that sentence. And so it's not as if we were entering into discussion with an entirely safe system. If we do that, we enter into the cloud, into the internet, and it leaves some tracks, if you'd like. It leaves some elements, which means that someone else who would start maybe typing the same sentence at another point, another place in the planet, could possibly receive as a suggested result the sentence that we inserted. So there is a clear risk there of course, if we insert sensitive data, disclosing, for example, a part of the secrecy of deliberations or the identity of an anonymized party. The lack of use.
This is really interesting, because then it's related to the example I mentioned at the beginning. That's several years ago, and I say because we have newcomers in the room. I already had colleagues, and maybe you as judges, maybe you used DeepL to translate even something you add in your files without knowing at that moment. I didn't know, maybe you did, but I didn't know at that moment that it was AI, and that indeed they could be a risk in using DeepL to translate some sentences or some elements that I had in my files. And this means a lot, because indeed it means that we must anticipate, and we must make everyone, and especially the judiciary, aware of these risks indeed. So I see that the Court of Justice of the EU is already and has been thinking about it, maybe, as you said, with a need for a governance model for AI within the CJEU, maybe guidelines, something like this. We have very short time slot for interventions, so maybe Stanislas, if you can
Yeah, I will.
end with elements that will help us to make the connection with Raffaele Sabato's presentation, because he also joined us. So we will have then parallel to make between the reflections from the CJEU and the reflections of the
Ingrid, I propose to wrap up in 2 minutes, if you allow me. Okay.
Yes, thank you very much, Stanislas.
Yes. So all that indeed led us to conclude that a governance model was needed, even prior to the AI Act. So we have established, as you can see here, so 3 types of measures. The first is institutionally the creation of an AI management board, which is diverse, reflects somehow the diversity of the courts, EU courts, in its composition. So we have the 2 courts represented, Advocate General, Judge. We have also a parity of representatives of the various services, which will be crucial in upholding the guidelines that they adopted in the future. That management board does essentially, as a first task, a classification. Its first task is to identify 3 types of activities. The so-called red lines, that is the activities for which there should be no use of AI at all. That goes further than the AI Act, as we will see in our later discussions. We even do not say here it's high risk. We say there are some activities for which the red lines is there, so no use of AI would be allowed. Then there are the areas of special attention. So use of AI needs to be carefully monitored. And that calls for mitigation strategies. For example, the risk of bias and discrimination requires to adopt safe and well-documented algorithms. So it is very important that not every single staff member uses whichever AI tool that he wants. We should coordinate and map out which AI tools are proper for certain activities. And of course, we also identify areas of low risk where, in principle, the existing practice could be maintained. That is, we are confident that staff uses AI in conformity with our rules of conduct. Here, I connect that to what you said, Ingrid. Our code of conduct for staff has been changed. It's new Article 10 is a very general requirement bearing on all court staff, requiring every court staff to remain aware of relevant developments, digital developments for his or her activities within the court, but also at the same time develop awareness about the risks they may involve. At technical level, we have the creation of AI algorithms within the court and that work of the DTI, as I said, which collects information in the outside world on relevant tools, and at resources level, and that connects again to what you said, we wish to train, that is upskill or reskill the workforce in all cabinets, and especially develop their awareness on the behavioral reflexes and attention they should be aware of when dealing with AI tools in, of course, a judicial, that is namely sensitive context. Thank you for your attention. There is a lot more to say, and I'm pleased to have Raffaele stepping in to explain us what the Strasbourg Court is currently developing as practices, good practices in this respect.
Thank you very much, Stanislas. But as we are very flexible and we are here in a round table, I know Pratik must leave, but I also see the connection, the direct connection with what you said, because we are talking about AI and the need to be trained on AI. And I know UNESCO is doing many things, and we are also partnering on that field. So I guess Pratik will mention it. So Raffaele is with us, and so if Pratik, you would like to take the floor now, so that we can also make the connection with the European Court of Human Rights afterwards regarding the artificial intelligence. Pratik Sibal, so you have the floor to present what UNESCO is doing on that field, as you are also, you have the same objectives to train judiciary.
Sure. Thank you. Thank you so much, Ingrid. And thanks, Stanislas, for the presentation. It's really interesting to know more about the court. Hello, colleagues. Thanks for the invitation. I'm Pratik Sibal. I'm a program specialist working on AI and digital transformation at UNESCO, and I'm leading the program around AI and the rule of law. It's great to see some familiar faces around the table, and always great cooperating with Ingrid and the team at the EGTN. I will keep my remarks to some insights from UNESCO's program on AI and the rule of law, some of the training tools that we have available, which can be used by different courts. I have a bit of a more global perspective, so some of the tools that we have developed look at global good practices emerging in this domain. And in the end, I will briefly mention a survey that we had done of the judiciary worldwide on how they are using artificial intelligence, and share a bit about the guidelines that UNESCO is developing. So this is a draft document, and it's in the process of being revised. So if I can share my...
It works.
Okay,
yes,
it works.
We can
Perfect.
see your presentation.
Perfect. So at UNESCO, our goal is really to start bringing international human rights standards to artificial intelligence, because in most countries, we do not have rules, AI governance laws per se. So the idea is, how can we apply international human rights standards to govern artificial intelligence? We do this through different activities. We do on-the-ground training of trainer workshops, also massive open online courses, and we have a network of about 36,500 judicial operators in 160 countries. And this is possible only through... Yes. Is there? Okay. This is possible only through strong partnerships with local and regional courts, working with national judicial training institutions. So thanks to all of you who are here. And we try to act also as a platform to facilitate exchange of best practices. We have several MOUs with Inter-American Court of Human Rights, with the East African Court of Justice, and notably we have EGTN as our latest partner, and we work through these organizations to nourish our global programs and to work closely with them. Now, how do we start? So in about 2018, 2019, we started to hear about artificial intelligence. And the challenge here was, well, what is it in courts that we need to do related to AI? So we went back to our community and asked them, what are the key areas that you would like to work on. And they said first the use of AI in administrative processes, which we also very clearly see in the Code of Justice of the EU's AI strategy. And second was what are the broader legal and ethical implications of AI that they need to know about when they are adjudicating cases. So based on this, we've developed.
You are muted.
Can you hear me?
Now, yes. We can.
Okay. So based on this feedback and also the UNESCO recommendation on the ethics of AI, which is a global standard setting instrument adopted by 193 countries, we've developed several capacity building tools. I'll share my slide so you'll have all the details, but very quickly, we have a global MOOC on AI, which is really a participative dialogue on what is AI? How is it being used in courts around the world? What is online courts? What is the different case law emerging in different countries? So we look at some of the good practices around the world. And then what are the case law related to human rights? And actually, a lot of the case law is from Europe here because courts have applied the GDPR. We are speaking in Italy. The Italian Data Protection Authority has done several cases around bias in algorithms for instance, for food delivery apps, whether it's Deliveroo or Foodino and so on. So we map all these examples from around the world. And then moving beyond individuals, we've developed a global curriculum, which is what we call the Global Toolkit on AI and the Rule of Law, which is really a 4-part curriculum where it has a training approach. So you have a lot of activities for helping judges, court staff, lawyers develop an intuition about artificial intelligence. So as Stanislas was mentioning before, there is a form of healthy skepticism, and not just that if a computer is telling us to do something, that must be right. So with that objective in mind, we talk about, as Ingrid was mentioning before, why is data important? How can we use data more effectively? What are the privacy concerns when we use AI? How can it lead to bias and discriminatory outcomes? How does it impact the legal principles around fair process, around due process, around fairness, and so on and so forth? So this toolkit is available in English, French, and Spanish at the moment. And this is actually what we used to work with the European Judicial Training Network earlier this year in July in Syracuse, where we had a fantastic 3-day training going into AI, its use in the judiciary, the legal ethical issues, human rights around, which had a mix of group interactions and interactive exercises. And we are implementing this model globally. We work with the Inter-American Court of Human Rights. Next week, we're doing it in Morocco, then in Africa, then in South Asia, and so on. We also talk about AI on a more cutting edge basis when there are emerging issues. For instance, we talked about AI generated evidence, and this is a very fascinating topic. How do you treat evidence where AI has been used? So we have a cycle of webinars here. Now, briefly coming to the more context, the content that I wanted to share. We are seeing uses of AI globally, but we wanted to understand how are judges and court staff actually using it. So we reached out to our network and we had responses from over 500 judicial actors from 96 countries. And we learned that 44% of them were using ChatGPT and AI chatbots for work-related activities. The frequency is, of course, different, but one would be curious to know what are they using it for. So about 43% were using it for search, basic search functions, finding information, and so on. 28% were using it for document drafting. Some were using it for brainstorming. So you want to basically try to reason out. Now, there is a bit of a challenge here. So there was a recent ruling from a court in Colombia where the court used ChatGPT to decide whether a child with disabilities should get medical insurance benefits or not. And the judge used ChatGPT and really in detail cites the process of how they used it. But this, in the end, they said the child would get the benefits. But this raised alarm bells if the judges are starting to use AI for legal reasoning and so on. If these chatbots say something which is actually not respecting the laws, then that will be creating problems. So the Constitutional Code of Colombia came up and said, well, we need to put in guidelines in place and so on and so forth. So here we look at different uses, but then there are also risks of this technology. And one of the major risks is on the quality of the output that we get from Gen AI tools. Then around data protection, as Ingrid and Stanislas was mentioning before, this data, if you feed into ChatGPT, it is going to use it for other activities as well. So one needs to be aware of how this data is used, whether the data is stored locally in the system or not. Then there are concerns around copyright and the black box issue of AI systems. Based on this, and Ingrid, I will be quick. Based on this, we have. I see that Stanislas, you've raised your hand. Would you like to come in? I don't see you, but.
Yes, I just wish to mention that, echoing what you've just said, both our AI strategy, the guidelines and the AI Act, therefore require that for the core of judicial functions, you have human control. But that raises a number of questions itself. So first of all, where lies the dividing line between what is the heart of judicial functions? In a nutshell, the AI Act says, recital 61, the heart of judicial functions should be subject to very far-reaching precautionary measures, including that human control element. So that is the first question. Another question is, do you not lose all the gains that you thought you would win through the use of AI if you require a human control of its output? So how do you reconcile the two? I'm not a specialist, so I'm just raising the question, including for the next speakers, because I would like to know how we resolve that almost paradox, I would say.
Absolutely. I will try to bring that point in a moment. But I hear also another voice, but not very clearly. I don't know if someone is trying to say something.
Yes, we were not hearing sorry, Pratik, but here we were not hearing the end of the Stanislas question. So I'm afraid we cannot hear Stanislas anymore. So we did not hear everything. But if you got the question, then you can simply react to it, and we can go on.
I can rephrase it, paraphrase it a bit also for everyone. So the question is, where is the line when you are using AI for core judicial functions, and where do you draw the line of the human needing to be in the loop? And that would, of course, slow down all the processes where you're using AI versus the efficiency gains that we get from AI. So where do we draw the line? And Stanislas was mentioning about the AI Act, where they say that the core judicial function, we should be very, very careful in how AI is using. And if I remember well, in the AI Act, use of AI in the judiciary falls under the high risk category as well. So I will try to come to addressing that question also. So in our survey finding, we saw that only 9% of the judicial operators who responded had received any form of training or institutional guidance. And they had asked, about 92% said, well, some guidelines on AI use would be useful. So what we've done is we've developed a draft for now, a guideline on the use of AI systems in courts and tribunals. We ran an open consultation on it for the past 2 months, and now we've received about 100 input from different parts of the world. So we are considering that carefully on how to revise it. I will walk you very quickly through some of the key elements without going into detail, but this document is available in English and Spanish for now, soon in French and Portuguese as well. So please feel free to go to the website, go through it. If you have any comments, feel free to write to me. We'd be very happy to engage with either national jurisdictions or the European courts as well. So we do 3 things in these guidelines. First, we articulate the main principles on how courts should use AI. And there are broadly, like for instance, in the UNESCO recommendation on AI, principles being articulated, but we contextualize those to the courts. So when we are talking about human rights, we're talking about fair trial. How does it that this is an important principle here? We talk about information security, we could talk about transparent use, we talk about explainability, we talk about human oversight, and here, reflecting briefly on Stanislav's point, we talk also about human in the loop. And in fact, in one of the consultation process, we received a feedback from a civil society organization that said, well, you should be actually even more careful and just talk about AI in the loop. So the humans are taking decisions and you put AI in the loop. And we are trying to see how does that make sense going beyond even human in the loop. And then we articulate guidance at the institutional level and at the individual level, because a lot of times it falls on courts or in the justice sector saying, well, it's up to individuals on how they're using, but actually institutions can take a lot of measures by doing impact assessments of AI tools that are being deployed, by identifying what are the risks in these systems and then putting in place risk management and risk mitigation strategies, whether it's around cybersecurity or it's around when does a human intervene if something goes wrong. Then also to define what are the functions of these tools. So for instance, we were talking briefly before about DeepL. It is being used for translation, well and good, but if you are using it by putting in personal information there, then it creates further risk. So there are so many other AI tools where we need to be considerate about what is the designed use and how are we using it and what are the risks associated. So these are some institutional guidelines, and going beyond, and this is my last slide, on the individual level guidelines, here again, we do recommend that there should be capacity building, training, and raising of awareness of judges and court staff about AI, but also them to be able to understand how to do ethical impact assessments, but not become experts, but to know how to do this, to be aware that personal and confidential data should not be shared. These tools should not be used as search engines for legal analysis, but always with the idea that you should be able to verify the output that these tools produce. And of course, be very transparent in how you use these tools by to allow also traceability when these tools have been used throughout the judicial decision-making process, but also when someone is using it in a court ruling to, for instance, put it under quotation marks and so on. So with this, I will stop here. There is, of course, a lot more to say, but thanks for having me. I'll hang out for a little bit more because I just find this discussion super interesting, and happy to answer any questions, reflections from all of you. Thanks.
Thank you very much, Pratik, for this very interesting presentation. Indeed, can you hear me? Yes? Oh, it's fine? Yes, yes. Okay, so they can hear us. So thank you very much for this very interesting discussion. Indeed, I stress that UNESCO is providing all the justice practitioners with a very useful and relevant documentation. So I definitely encourage you to go on their website and look at what they have. And indeed, we are working closely together because UNESCO is also bringing us a worldwide reflection on AI especially, and it confirms Pratik is doing a wonderful job with his team at UNESCO. It confirms that there is a definitive link between the digitalization, the AI, and the rule of law, the human rights. So this is exactly, I think, the perfect transition, because we got already the point of view of the CJEU, which I think maybe there will be room for joint activity or something. We must think about it afterwards. So here I'm looking at Stanislas and Pratik, so maybe this is room for discussion afterwards. But we have also this perfect link with the European Court of Human Rights, because indeed digitalization is also a challenge, is especially a challenge on that field. And here I would like to hear our distinguished guest face to face, Raffaele Sabato, who is a judge, Italian judge at at the European Court of Human Rights, but he's also a strong and close friend to EJTN because he has been working for EJTN for a long time, and many people at EJTN remember him. Indeed, he was also with us last year in Syracuse, and here I also brought the book in which you can have either the contribution of Stanislas but Raffaele Sabato as well. You were already together, and that we drafted with indeed Gianluca Grasso, who is also there. So I leave this for the face-to-face participants. So if you want to have a look at the book, it's available. But in the meantime, I would like Raffaele Sabato to take the floor and express the ECHR's point of view.
Thank you, Ingrid. Thanks to Paul and everybody else. It was a pleasure listening to Stanislav and Pratek. In my 8 minutes, I will give a very short summary of things that we said this morning and some other things that I've prepared for this afternoon, which are, and this testifies that we have to update our standards on my traditional AGTN USB key, which, however, doesn't fit in the system. So you will see the slides afterwards. Let me say very shortly. So starting with the same way that Stanislav presented his topic. So we have basically two retrieval systems which are within the court and are confidential. One retrieval system is our general management system. It's called Court Management of Information System, CMIS. So you can imagine it as a sort of register of the cases, as a toolkit to take notes for the case lawyer and the judge, etc., a history of the correspondence and the possibility to push on each of the events, etc., and to go to the second system, which is a regular document manager that we all know that other courts may also have. The first one is a proprietary software. This one is provided in a way by Microsoft, but it can fit within the Microsoft document management, so Word, Excel, etc. So you can have little icons in there to access directly to this document database in which you can see documents by way of a viewer or by downloading them. The rules that do not concern AI for the moment are that we should not exchange correspondence enclosing documents, but by enclosing references to the database so that only colleagues that are within the system can see the documents. And so we have to be very, very careful as to when we enclose something which is for the outside, that it's not confidential, it's not secret, because it may even be secret because we do interstate cases and other very important cases that are sort of classified. But so this is basically the framework of documents. For the moment, on all of these documents, we have no artificial intelligence being applied. Then there is a research engine. Unlike Stanislav's example, where Eureka in Luxembourg is accessible only to those working in the court, our system, HUDOC, H-U-D-O-C, Human Rights Documentation System, is open source. It's not open source, it's open for the public. We have the same system for inside and outside. Knowledge sharing a year ago, the public those that you know So you, which is a, you know, this for. So, having said this, now I have to go to the second part. The only study we are much slower, of course, if you only think of the constituency in terms of states of our court, 46 states, many of them having also issues in having internet on their territories, some of them being in very tragical conflicts, etc. You can imagine that we cannot go too fast. Still, lots of papers is employed. Applications to the courts are made on paper. There are systems to send, especially requests for provisional measures by way of an information technology system which is accessible to the public, but still the paper is very important. What was done a few years ago, and this was it was in my slides, is a study in cooperation with some universities, one in the United Kingdom, one in the United States, and they tried to apply a model of artificial intelligence of a predictive type in order to assist in deciding a case. So the experiment was to put in the system 250 judgments that already existed, selected, however, because of the topic that were, sort of standardized topics. So Article 2, Article 3, and Article 8 cases, and the system sort of guessed by analyzing the facts and the law, guessed the outcome in about 75% of the cases. So this you can put on Google Aletras, who is the main author of this study, and you will find information on this experiment. So if you project this to the future, you could apply to UDoc this system and to retrieve on the system information on a new case, and you could theoretically see what the outcome could be. This is very, very scary. It has not been done. The second part of my slide on this topic was concerning what the instructions for us judges and the lawyers, similar to what was decided in Luxembourg, are concerning the use of existing chatbots. The instruction we have, which is very, very binding, is that we should not use any of this system at all. And if we do for private purposes, we should be very, very careful that within our private information, no court information gets inside. Of course, all of us have done our experiments in the real things, and with appropriate precautions, we are learning how to use it. A couple of weeks ago, so very, very recently, while a committee on working methods is dealing with this topic, the instruction came that our main provider, I will not make the name, although I mentioned the systems before, which integrates in this DM, data management system, agreed with us, and I think that they are agreeing it with most of the courts and the judiciaries worldwide, that if we access their own chatbot by way of our official accounts, the system will not save any of the information that we put inside. That their analysis of the data is done only for the purpose of replying, and nothing will be the subject of data analysis afterwards. And However, the court recommended that in this moment of experiment, we only use this chatbot for ancillary work. So to answer mails inviting us to conferences and other things, although, you know, even those things for security might contain dangerous information. So basically, I'm starting to using it. Please consider that, and this has already been addressed by Stanislas, who said that, you know, everything should be converted into French for them. We have two official languages, English and French. And of course, the documents and the exchanges that we have on cases might be in any of the several languages that are the languages of the cases. So my approach to this is that you can at the same time ask the system to analyze data or reply to letters or make other correspondence, and at the same time ask that it be translated into British English, because most of the systems use American English and we don't, and or French. The time is finished. I wanted to mention something that I think is quite important, because Stanislas went into some topics regarding the AI Act.
Sorry, Ingrid, Raffaele, we have lost you, I'm afraid. Giuseppe, you have the same issue? Stefano, you have the same issue. We have lost them, it seems to me.
Yes, we cannot hear anything.
Also, the main camera is freezed.
Yes, maybe the line, Capri.
The line is not so good.
It's not stable.
Ingrid, we've lost the connection. It seems to me.
Okay, they come back.
Yeah, okay, so it was the last thing you were about to mention.
Yes, I was mentioning that I wanted
the reason why I interrupted you, Raffaele, is that I'm very, very interested in what you want to say about the AI Act.
Sì, è vero.
Should I resume?
Sì.
Yes. So I was saying, I was trying to reflect from the Strasbourg perspective what Stanislas said concerning the AI Act. And I was mentioning that exactly 1 month ago, the Commission signed the Framework Convention on Artificial Intelligence, which was drafted earlier this year within the Council of Europe after 2 very full years of work done in cooperation with the European Union, the Luxembourg Court, and many At the same time, we keep account of the AI, of course, and also the preparatory works and the works of these very important committees that we have in Strasbourg, the CEPEJ, which drafted an ethical charter for the use of artificial intelligence in the judiciary, and the works of these 2 committees, one of them dealing with cyber justice in general, and one of them being the one which prepared the convention, so dealing with artificial intelligence. The final sentence I wanted to make is that my court will devote its judicial seminar, which usually accompanies the official opening of the judicial year on January the 31st, to the topic of artificial intelligence in the judiciary. So we will have all the top court leaders in Europe, in the larger Europe of the 46 states, discussing this topic and possibly getting some information shared and opinions shared after January the 31st. I have the honor of being the senior member of the committee which is organizing, so I will be able to tell you more in the future. Thank you.
Thank you very much, Raffaele. So is this event recorded in a way, or do you know already if we? Yes. Wonderful. Thank you very much. Yes. Thank you very much. And indeed, it is clear that everything is evolving very, very quickly. So this is definitely what we see. Also at the level of the European law and the European conventions. And we are lucky here because we have distinguished guests, and we have also guests who can talk to us about the negotiation and the way the European regulation have been discussed in the previous years, what is coming also because they have the experience of this negotiation at the European level. So I'm afraid I don't know Rosario Amendolia. I did not have that. So you are Rosario Amendolia, face to face with us, and indeed. This is the moment where I think your insights would be really interesting because you have you were working as a representative of the Italy at the permanent representation at the council. So you are able to tell us more about what the discussions were about, and indeed how all the challenges that we are mentioning now were taken into account also when you were doing that job. I know that now you are more at the national level, at the DIT, which is, if I understand well, the department in Italy, which is in charge of the digitalization as well. So it's interesting that you can also make the connection with your previous experience and the experience you are having now, taking into account also what was already said as challenges, threats, and opportunities, of course. So, Rosario, would you like to take the floor?
Thanks, Ingrid. Yes, I attend to the discussion about the e-justice strategy at the European Council in the e-justice group, and we are preparing the conclusion for the Council of Ministers of Justice and Interior Affairs, and just few words. I don't want to take too much time about because your intervention were very interesting, and my reflection is very brief. The common principle discussed at the European table and in Italy, where we are trying to build a rule to apply the European regulation, is that the artificial intelligence must not substitute the judicial activity, the judicial decision. But it isn't only a prescription. It's a matter of fact. Because if the judge is not prepared to understand how artificial intelligence works. And if the judge is not enough skilled on traditional methods, judge has the control efficiency. Because I control the machine work. If you don't know how it works, if you go now, the principle is if you can't decide by yourself, by your brain, your case, you don't have to use artificial intelligence because artificial intelligence is deceptive. So artificial intelligence can help you and not substitute you if you can do as the artificial intelligence do, but slower. So I think that the main challenge for the policymaker in Europe and in Italy is to give limits to the abuse of artificial intelligence in substitution of men's or civil servants not prepared, not skilled. So we have to foster the skills, to foster the training, not only in the traditional method, but in science, in computer science, in mathematical sciences. That is the only defense to the abuse of artificial intelligence. Just these words, and I leave the floor. I give you the floor to prosecute this interesting discussion.
Thank you very much, Dario. This is indeed very clear presentation, and you are absolutely right. This is why we see that there is definitely a need for judicial training, and as you said, the most relevant judicial training would not only be legal. It is also something else, because now we are facing a challenge that we did not face before, and which we must take into account to elaborate the content of our trainings. And here it is the perfect connection also with the presentation that Paola Giacalone will make, because she's a researcher, a specialist in digitalization and access to justice. And indeed, this digital era is raising many more questions. Also, the evolutions that we have had now and that we will have in the future. And I know that Paola has already identified some technical issues and also some technical field where digital training for the judiciary is absolutely needed. So maybe Paola, you could take the floor also.
Okay. Thank you, Ingrid. Thank you very much. Thank you, everyone. It's a pleasure for me being here today with you and talking about the challenges digitalization poses in civil judicial cooperation. Let me share with you some slides. Yes. Okay. Here we are. Can you see them? And access to
We can't hear you. It's been
Yes.
I have a
freezed,
problem
actually.
with my slides.
No, the slide is blocked, but we cannot hear anything.
No, but can you see when they change?
Yeah, but we lose the connection, so we can't hear you. We've lost
Okay,
you
it was
for
the
2 or 3
connection.
Now
minutes.
maybe it's
Ah,
back.
ok, era la connessione. Sì, sì.
Sorry.
Provo a fare col mio telefono, potrebbe funzionare meglio?
No, now we can
Teams.
hear.
Provo? Ok.
Now it's working again.
It's fine, Paola, now.
It's fine now?
In
Yeah?
this moment, yes,
Okay,
yes.
I will try. Thank you. Thank you. Okay, so I'm going to divide my presentation into two parts. The first part will be dedicated to the European Union regulatory framework on digitalization in civil judicial cooperation. Then I will try to offer you some positive remarks and some doubts about the application of this regulation in this specific sector. So first of all, let's start from the basis, the legal basis. So the digital decade of European Union Commission for 2030 as a very ambitious goal. This goal comprehends 4 different objectives. First of all, a digitally skilled population. Secondly, a secure and sustainable digital infrastructure. Thirdly, a digital transformation of businesses. And fourth, digitalization of public services, where the judiciary gets in. So if we look very closely to that pyramid, we can see that at the bottom, we have all those objectives, but at the top of the pyramid, we have digital values that are in line with the European Union values and principles. So we should keep in mind that this digital decade remembers us the real relevance of European Union principle and European Union values that needs to be respected. So at the moment, what are the current sources of digitalization? As it was mentioned before, the e-justice strategy 2024-2028. I know that right now, European Commission is looking at the new European Union digital strategy. And then we have the 2 fundamental regulation and directive in this field, that is, they were both enacted in December 2023. Then we have today, we listen to all those contributions that talked about eIDAS, regulation for digital signature, and service of documents and taking of evidence regulations, and of course, e-codex regulation. So this was the regulatory European Union framework. Where does the digitalization regulation stand? Well, we have 3 main objectives in these regulations. First of all, the establishment of a European electronic access point. And there is, as you will see, a decentralized approach, because European Union realized that we really need to focus before standing on a concentrated, so a unique approach, a European Union one. We had to make a higher level of digitalization into national systems. So then the digitalization regulation provides a possibility to lodge a claim electronically. And thirdly, service of documents can be reached through the electronic access point. only with prior consent. And this consent can also be revoked. What does this mean? It means that European Union Commission and the European Union Council realize that there is a bit of reluctance from domestic jurisdiction, national member states, to accept the principle digital by default. So this is the reason why you will see now that there is a gradual level of digitalization. How? We have new keywords, as you may see from this regulation. First of all, as I mentioned before, digital by default principle. What does it mean? What is the meaning of that principle? This is one of the main characteristics because we find that principle in the in the first recitals of these regulations. And then we have the interoperability, that is of regulation. What does interoperability mean? It means the ability to be interconnected between different judicial systems, not only inside each state. So, for example, civil law should be interconnected with criminal law and so civil law in Italy and in France and all yeah, I'm changing my slides. I did not see.
Slide block.
Yeah, slides blocked. Yeah, yeah. Can you hear me now? Yes?
Yes.
Yes, okay. So here you can see I have put my roadmap for digitalization of civil judicial cooperation. And if you look at it very closely, you may see that the digitalization proposal finished actually, because this is a regulation that entered into force in December 2023, together with the directive in this field. And you see this gradual digitalization in civil judicial cooperation, because we have 4 different batches. So there is, the point is that European Union Commission and the European Union Council decided to implement this field slowly. So to allow European Union member states to get at the same rhythm with digitalization. So if we look closer, we have 4 different batches. And just to enhance what I said before, you can see that looking at the timeline, in the first batch, regulation that are the easiest ones. So small claims regulation, European order for payments. So the ones that can be digitalized easily are in the first batch. Then we have in the second batch, for example, legal aid, the European account preservation order. Then in the third batch, we have succession, freezing order. Here, in the fourth batch, we have Brussels 1bis regulation. So the father of all these regulations, and the one that is harder to accept entirely digitally. So when to expect the decentralized IT systems? As I said before, implementing acts will follow. So they will be adopted in 2, 3, 4, 5 years from now. So since they entered into force. So this is a gradual digitalization, a staggered approach. And we have, if we look closer, the first ones that will be digitalized are service of documents and taking of evidence. They are already doing it because it started in December 2022 and it will be ready in May 2025. Then we have, as I mentioned before, European Order for Payments, small claims, just at the end, Brussels 1 bis and parenthood. So in my research group at the Vrije Universiteit Brussels, we started a questionnaire on the digitalization according to a European Union project we won on the digitalization in civil commercial matters. And we realized that we wanted to know in a survey what was the level of digitalization of those member states. Because there is a phenomenon so-called digital divide that allows us to understand that there is a differentiation between different level of digitalization in each member state. So we wanted to know what was the medium level of digitalization in European Union, and we realized that judicial work processes are still largely paper-based, and video conferencing are still an exception. And we also realized that the use of different methods in member states also raised questions of interoperability between those systems. So then another very important question that we faced in our research, what about the cost? Because everybody talk about digitalization, but who should handle those costs? So we can split responsibilities. On one side, we have the Commission that owns the cost of creation, maintenance, and future developments of reference implementation software. And European Commission also provides and maintains support to member states for the implementation of the software components in the decentralized European electronic access points. On the other side, member states should have the cost, should bear the cost of installation, because the electronic access point is in each member state. So the cost of installation, operation, and maintenance of those access points. So what are our future perspectives? Well, obstacles to that digitalization regulations we can divide them into three. We can classify, first of all, the technological gaps, as we mentioned before, the digital divide phenomenon. So disparities between member states in technology adoption. So some member states, such as Estonia and Lithuania, have a higher level of digitalization. And compared to Italy or to France or to Belgium as well, they can teach a lot. And if we try to compare those different national legal systems, we can take some benefits from that comparison. Secondly, cost, as we mentioned before, the financial burden of adopting new technologies across diverse legal systems is very expensive. And then there is a resistance from judicial professionals that can resist changes due to complex legal proceedings and traditional workflows. So can we be optimistic? Yes, of course. Despite the risk, digitalization offers immense benefits if properly safeguarded, and the systems of interoperability are necessary to ensure seamless cross-border cooperation and avoid disparities in judicial outcomes, because when we think about cross-border implication, we should never forget the possibility of to avoid different judicial outcomes. And as Ingrid already said before, we truly believe that knowledge is necessary. So the possibility to offer training programs for legal professionals, once on a side for digital literacy, so to help them be aware of the new meaning that are provided in the regulation and the recital of the regulation, and also the new way those claims should be lodged. So digitally, electronically. So let me finish with a very famous quote. When digital transformation is done right, it's like a caterpillar turning into a butterfly. But When it's done wrong, all you have is a caterpillar. What do I mean by this? This is a very famous analogy that I wanted to share with you because it means that, as we have seen in this seminar, technology is going faster, so fast. So we should try to be ready on time, at the same pace, at the same rhythm of this digitalization. Otherwise, it will be too late. Thank you very much for your attention.
Thank you.
Your insights and the outcomes of your researches, which are indeed very interesting to feed our reflection. We are all going to the same direction, that we must accompany that digital transition with the judicial training, because otherwise we will have only a caterpillar. So this is the challenge we have. And indeed, last year in the European regulation, it is mentioned that judicial training must be enforced in order to accompany the digitalization of the cross-border cooperation. And you shared with us, you reminded us all these implementing acts which are coming and which will be definitely a challenge. And here I would like to get the insights of Stefano Nativi, who is working at the permanent representation of Italy to the Council of the EU. Stefano, you are immersed now also in the reflection, in the negotiation of the regulations, the EU law, which indeed is related now with this challenge of digitalization. I know you have prepared your presentation, and I guess you will also talk about the need of judicial training, or maybe to say, at least, if it is taken into account in the discussions you are currently having at the permanent representation, if all these challenges are rightly beared in mind by all the actors of this digitalization process, and which are your main challenges at that level. So Stefano Nativi,
Can you hear me?
Yes, we can hear you.
Can you see my slides?
Yes, we can.
Fantastic. Well, I mean, thank you for having me here. And well, I mean, as it was done, I've been part of the negotiation of the famous AI Act and also others. So, I mean, today I will try not just to cover the AI Act, but also to broaden the landscape and talk about, for instance, ADAS. Paola already mentioned it, and other next coming pieces of legislation. My main contribution today, since I'm coming from the technical side, is to explain a bit more what is under the hood when we talk about this digital transition. And I share what Paola said. I mean, this is not a real transformation. This is a transition. So it is lower and certainly not very deep. I'm not saying that it is good or it is bad, but, you know, we must, take into account that this is the fact, you know. So also Paola already mentioned beautifully that, I mean, a very important policy agreement was the so-called Digital Decade Policy Program, in order to push the digitalization of Europe, of the European Union. And as it was said here, there are 4 different sectors, or areas, if you like: skills, infrastructure, businesses, and public administration. In my view, the transition for the judicial system needs all the four sectors, targets. Today we are experiencing how infrastructures are so important. I mean, we cannot talk remotely if we don't have high capacity, networks. So, I mean, it is not just the public services. It is, beyond. Skills was already covered several times, and I will try also very quickly to mention business, how to embrace digitalization by business is also important for the transition of justice. But of course, I mean, we all know that an important target for the public administration is to have 100% of the key public services online by 2030. Very ambitious indeed. Okay, so an important part of a digital decade policy program is the so-called single digital market. What is the single digital market? I mean, that means a set of developments, the so-called objectives that you can see on this slide. So remove the digital barriers and create a unified market, a unified space for online services, public and private, of course. Encourage cross-border data sharing and harmonization of digital services. So basically interoperability was mentioned in the previous presentation across member states. Once more here, there is always this objective. This is not just at the national level, but it is, of course, at the European level. And then to ensure that this is done taking into account, privacy, data security, transparencies, human rights, etc. And finally, to build the trust from citizens on a digital solution, in this case, the digital justice platforms. But this is true for any other, sector of this digital economy where we live today. So I guess that these are the actual objectives of the justice digitalization. So pushing the single digital market, it is the starting point if we want to achieve an effective and useful digitalization of justice across Europe. And to do that, the European Union, so Commission, Parliament, and Council, they develop a set of regulations. And here I would like to distinguish between technical regulation and legal, regulation. According to the European system, which is different, for instance, by the US system, the technical regulation are quite often part of a legal, regulation. They are called implementation acts, if you like, but if you don't have this implementation act, you cannot really implement the legal regulations. So this is what is going on, what has been done recently, and what is going on. There is this stack, let's say, of different areas where the single digital market has been developed in the last years. And you can see, for instance, there is the data, so data interoperability, data sharing, data collection, data use, etc., etc. Then there are the technological or technical services, operational services, cybersecurity assurance, and then supply chain and geopolitics. But I mean, today I don't have time, so we just say something about the blue layers, and not certainly the green and the red one. And here I try to, summarize what are the most recent approved pieces of legislation. So it was mentioned, of course, AI Act on the bottom right side. This entered into force in August of this year. So there are 24 months in order to fully implement at the national level. But I mean, since it is really important, AI, as of 2025, we will have some parts of this act already implemented. For the others, generally, there is this grace time of 24 months in order to implement it. So Data Act is another important regulation because defines actual rights on the access to and use of data. So these so-called digital evidences, they are data, I mean, largely. They can be, you know, text, they can be movie, they can be pictures, I mean, whatever, tables, I mean, whatever, but they are data. So it is important to lower barrier and to, you know, push in interoperability across member states, having always in mind, you know, privacy, security, and transparency. Then the Data Governance Act, establishing a framework for facilitating general and sector-specific data sharing. Then we have EIDAS. It was already mentioned. EIDAS defines the EU Digital Identity Wallet, including a platform for qualified signature. So this is absolutely important when it will be fully implemented in 2026 for you know, establishing the trust between citizen and public administration, and not only public, of course. Interoperable Europe Act is another example, the famous GDPR that we all know, and so on. I mean, also the Gigabit Infrastructure Act is important because if we want to have these virtual, you know, processes, we need, you know, high capacity and reliable networks. Then, of course, as I said, there are operational and technical regulation, Digital Service, Digital Markets Act, and Cybersecurity, Digital Operational Resilience Act, Cybersecurity, Cyber Resilience Act, etc. What is important here is to stress that they are horizontal regulation. So they are across the different sectors. So this is what I can say, the baseline, okay? Without this, it is not possible then to develop specific or vertical sector pieces of legislation. So in your case, of course, we are talking about the justice sector. So, I mean, what are the benefits? Of course, I mean, you already mentioned several, so I just played to, you know, come up with three main strengths here. Help developing a faster and more efficient proceedings. You already mentioned these, I mean, instruments here are digital communication, digital evidences, so how to collect, share, and evaluate these digital evidences, facilitate cross-border legal cooperation, enable data-driven judicial reform. So also data is not just useful into the you know, trial, but they are also useful about the trial so that it can be managed you know, better the system itself. Then the second strength here, it is about an increased access to justice across the European Union. This was stressed several times, and here instruments are online dispute resolution tools, and finally, I mean, cost. This was mentioned previously. I mean, reduce legal and administrative cost in order to develop a fully digital court system and integrating as much as possible with all the limits due to privacy and human rights and transparencies, but certainly it is useful to integrate artificial intelligence into the legal systems. So here I try to come up with the most relevant pieces of legislation for each of these possible benefits. So, for instance, for cross-border interoperability, Interoperable Europe Act, EIDAS, so digital identity, the Data Governance Act and the Data Acts, are certainly relevant for online dispute resolution. EIDAS, the Gigabit Infrastructure Act, the Digital Service Act, the Data Act, the Cybersecurity Act. But, I mean, you can, see how they are instrument, all these regulations and technical implementations are instrumental if we really want to build the digital process and if we really want to, implement this transition of justice and, of course, artificial intelligence. You already mentioned several times, just a message from my side. When we talk about artificial intelligence, we think that, it is largely about models. So how to understand models, how to explain them, what are the algorithms, etc. This is true, of course, but you need three, enabling factors for artificial intelligence. You need data, so really a lot of data. So how to collect, share, and use data across EU. The second is processing. You need clouds, basically computing, but also, high performance computing. And finally, the artificial intelligence model. So in order to, have this digitalization, we must build all these free capacities. And so data is certainly as important as models here. Just a few words about why the European Digital Identity Wallet is so important for a digital justice. Well, I mean, it is going to develop a single European digital identity for all the European Union citizens, but also residents and businesses. So this is legally, accepted throughout the entire EU. And so, I mean, you don't have to move, and to go.
I am very sorry, Stefano, but we could not hear you anymore. And here I would like to ask you to kindly come to an end, because we still have many speakers, and your presentation is very interesting. So I would like you maybe to wrap up in a nutshell what you want us to keep on board with in our reflection. Could you please do it for us?
Yeah, sure. I mean, I think that my main message was already, convened. Just a comment, because you asked whether the AI Act classified the justice and law enforcement services as high risk. Indeed, I can confirm that. And just one last slide saying that also the private sector, so businesses, is going to change due to this digitalization. In particular, the legal industry, the law firms with the generative AI are going to change in terms of automated legal research and document drafting, improve client services. Challenges and ethical concerns are still important, of course, here. Efficiency and cost reduction, and therefore clients are going to expect a more competitive, service and less cost. And then predictive analytics and decision making are going to change also the traditional role of the union lawyers. And that's my last message. Thank you for your attention.
Thank you. Thank you very much. You made very clear that it's a huge transformation, which covers many fields with many hacks, and it's rather technical for all of us anyway. And here we would like to have the insights of Giuseppe Buffone, who is also working at the permanent representation of the Council of the EU, representing Italy. Maybe Giuseppe, you could take the floor to explain how important this transformation is, especially with this digitalization package. So thank you very much for being with us, and you have the floor.
Thank you very much, and thanks for, really it's an honor to be here. I will try to be very short and fast. I will share with you my presentation to respond to your question, and hope that you can see it now. Okay. You see it?
You
Now?
don't see it online, Giuseppe.
Okay, I'll try again. Sorry. Now you see it?
No.
I'll try again. Condivisione schermo. Okay, now you see.
Yes.
Okay. Well, yeah. Okay. Now you're seeing it.
Yeah.
Yeah. Good. So my idea is to share with...
on the presentation.
Okay. My idea is to share with you the most. It's okay. Everything is okay.
Yes.
Yeah,
It's
okay.
perfect.
So I want to be, what I will focus on is, generally speaking, the overview of the most important new instruments that deal with digitalization. And obviously, most of them was negotiated recently, and some of them are still ongoing. Why I want to touch this point? Because I want to underline that when we talk about digitalization, we're not talking only about technologies, but we are also talking about fundamental rights. And all these topics refers to the justice system. What I want to underline as a premise, and I would like to mention what Stefan already said, is that in this period, digitalization is not just a modification, it's a real transformation, it's a big change. And I use the term of transformation as recently Professor Muller used it, making a distinction. When we talk about modification, we're talking about something that is already there and we change it. In this case, with something totally new. So we are introducing something that wasn't there before. That's why this is a big change. We cannot talk only about modification of our judicial system. It's really a transition, as Paola and Stefano already said. What will be my points? The first point will be a presentation, a short overview of the new legal framework. And secondly, I will focus on some questions with you. Questions that obviously are big questions, according to me, and are already discussed at the EU level, but not only in the EU. Legal framework, I will be very short because already Paola touched some of these instruments. When we talk about digitalization, we must also talk about AI, and there are a lot of new proposals already recently approved. First of all that deals with AI, and it's important, according to me, not to mention only the AI Act, but also the two proposals that are changing AI from another point of view. I mean, the new Productive Liability Directive and the new proposal on AI civil liability. This is the full package on the AI. On the other hand, we have the big new instrument for the communication, obviously e-communication, namely e-codex. And at the end, the big digitalization package. On this package, I want just to focus in the next slide. But before, I want to inform you about the AI package. For what concerns the Civil Liability Directive, it was suspended last year, and then it was resumed this year. I don't know if this proposal will come to an end, because there are a lot of critical points. We have no time to discuss on the substance, but I will be very glad to share with you the big problem if in case. PLD, the new Productive Liability Directive. This is a Grundnorm of the EU cooperation, and as you know, is instruments that also obviously concern national cases, not cross-border cases. It was approved, and luckily we will see it probably next month in the official Gazette, because we waited for the EU Parliament to approve it with the so-called corrigendum procedure. AI Act, you know, it's already a law, and I know that there will be a long road for the implementation, but the first provision will be already applicable next year. What I want to underline is that digitalization, from this point of view, has a main goal to connect national systems, to create a common judicial area where communication can be electronic. And pay attention, the system that we will use is e-codex. On the point of view of the digital justice, and I will mention what already Paola said, we have really a revolution on our main instruments of cooperation. I refer to the regulation of service of documents on taking on evidence and the big package on digitalization. Why it's a big modification? Because all the judicial cooperation will be inspired by the principle of digital by default. Pay attention, the system that we will use is e-codex. And on this point of view, I want also to inform you, but maybe you already know, there will be also an important change on the hearings, because on behalf of the digitalization package, hearings will be, as a rule, by video conference. And that's why all the experts like Rosario, my colleague, and others are working on the national level to create the possibility to connect systems, even what concern this kind, for instance, of instruments. But now we will focus on the two doubts, and I will conclude. Not doubts, but big question. And I will introduce this question, informing you about the last important political messages sent by the EU Council. I refer to the Council conclusion. They were approved in the last 2 years. Why they are important? Because they focus on digitalization from another point of view. The first of all, digitalization as an important element to grant access to justice. On another point of view, obviously, we already talked about the problem of digital divide, but in this case, we are talking about the problem that a lot of people cannot use digitalization. And I'm glad to hear about, for instance, the importance of training. But in this case, we are talking about training of expert operators. I refer in this case to normal people, all people, people with disability. How can they access to services if they are digitalized, but they can't? And why all this conclusion, for instance, focus on this aspect. The last one, the importance of have a digital area that is safe, secure, and for instance, protected, not only from cyber crime, but most of all from, for instance, hate speeches. And I want only to, last point that I will touch here is what's next. In this moment, the Council, the Presidency proposed a new conclusion on the use of artificial intelligence in the field of justice. These conclusions are under negotiate, but they are like a promise of what the Council, how the EU want to use AI in the field of justice. Obviously, you know the legal, the nature of the Council conclusion, they're not binding, but they represent really an important point from the political point of view. And now the relation between law and technology. First point, rule of law. We mentioned it. Why I mentioned rule of law? Well, it was 2008 and Natalie 2008, and in a very important forum concerning the public administration, Natalie Noirti, a very famous scholar, you already know it, you surely know it, raised a question concerning the relation between law and technology, namely, is it law that governs technology or the contrary? Because at that time was for sure that law was at the center of legislation. It was, for instance, the main guardian of rule of law. But now, because you know, what is sure is that technology runs through everything. You cannot stop it. But are we maybe in front of a big change, even concerning the scale of value? I mentioned Natalino Irti, but it's funny that his question, and you remember, was 2008, was recalled in a big EU Digital Forum of 2021, organized by the EU Commission with Commissioner Reinders. At the time, well, the same question arose about the irresistible legislative nature of technology. And in this case, the main goal was, well, we cannot stop technology, but we can rule it. Last question, the scale of values. Everybody here and also me are talking about digitalization as something very important, but let's reflect on it. Digitalization is not the goal. Digitalization is the mean, not the end. I mean, we are working on digitalization to offer a better justice, to better protect rights. So we must celebrate digitalization as long as rights are protected. So we cannot intend digitalization as our goal. Digitalization is our road. And that's why recently I heard this quote that I liked very much. Transformation is a journey, not a destination. Thank you very much for your attention.
Thank you very much, Giuseppe, for this very inspiring presentation. Indeed, we are in a journey now, and in our journey, it seems that we are always running after time. So this is one of our main challenges in all the fields, and also in the organization of these events. So here, I would like to jump up very quickly with the other speaker. We have Luigi Romano, who is a professor, who is a teacher at the University of Partenope. And indeed, you raised many questions, indeed, Giuseppe. So I guess that also in the field of the teaching, Luigi Romano has some, and maybe can already share some insights that then we will connect also at the national level, because indeed we will be transitioning slowly into national perspective. So we can just give you the computer so that the participants are online can see.
Yeah. Okay, so actually I didn't think I was supposed to have a slot, so I did not prepare slides. So my apologies for not having slides, but I can provide like a set of slides afterwards. It's not a problem. I'm a technical guy, so not a lawyer. I'm an engineer. I'm an expert in cybersecurity mainly. I'm a consultant to ENISA, the European Agency on Cybersecurity. So very interesting talks. But you know, I would be very brief also because I know that we're running out of time. Just a few thoughts about something that I think has not been touched upon in the other presentation. Actually, I lost the first maybe 15 minutes or so, so I'm not sure, but I don't think it was mentioned. So in one of the presentations, it was said, you know, technology is already there, it's ready. Well, I wish it was the case, but it's not. There are some open issues also from the technological perspective. As an example, there were several mentions on interoperability. Interoperability is not an issue in it, meaning it is an issue since we are not there yet. It's not implemented, but at least we know how to do it. What is an issue, and it was not mentioned in the talks, is sovereignty. So there were several mentioning of the tools that are used. So if I see in the objectives integrating AI in the process, in the management of the processes and on all the work that is being done, what does that mean? I mean, somebody has to develop the AI tools. And, you know, Sabato, he mentioned it that, you know, there was a system by Microsoft, you know, you know, so there is an implicit trust in third parties, which are totally beyond the context. So my question is provocative. Would you use, so you're assuming that AI, there was also a mention, we have to learn how to use AI right. Yeah, but we are assuming that AI is right in the first place. But since it is an implementation, so you are implicitly assuming that you trust the provider, which is quite a strong assumption. So my question, my provocative question is, if it was produced by Huawei, would you use your AI tool for your process? You know, if we go back to when we were supposed to do the transition to 5G, so Europe didn't do the transition because the technology was Chinese. So this is the same because we didn't trust Chinese. So first, I think it is very dangerous, these implicit assumptions of trust. So we should zero trust. We should switch to a zero trust model, or at least we should assess the trust that we are assuming. So because we cannot, so the answer would be, okay, so the tools are provided by third parties. They are out of control. So what are you going to use? What are you going to, you cannot say I'm not using it, because we have to make this transition. That is out of discussion. But at least, so if we are not able to build the technology ourselves, at least we must be able to assess in a reliable way to what extent we can trust the technology, even if we do not produce the technology ourselves. And I think there are important steps that the National Cybersecurity Agency is taking towards this step by the certification labs that they're setting up. So I cannot say I'm not using the tools if I'm not able to produce a tool myself, but I must be able at least to assess the tools that comes from outside. And also I made things very simple because I said, you know, if it was Microsoft, so it's Microsoft you trust. If it was Huawei or Kaspersky, you wouldn't trust. But it is even more complex because, you know, I know when I think it is made by Microsoft, I only see the end of the supply chain. So I don't know how many of you remember when there was the big cyber attack due to cameras. Okay, so it was cameras by Panasonic, Sonic, and so also brands that you would trust. But under the hood, there were components which were produced outside. So I should be very careful trusting anybody, and I should also try to understand what is under the first level, the front end, because it is a problem of trusting the entire supply chain, because ICT products are not simple things, are very complex systems, what they are calling systems of systems. So I should be able to really understand what is the real level of trust that I can reliable assign to them. And I don't want to steal more time. So again, this is just some thoughts that came to my mind. And then there is another wide, which is not also the data sovereignty. Somebody said, you know, I have to allow access to the data, but also I can change my mind. You know, that's easily said, it's not easily done. So we are also seeing from the technological point of view a transition, not a transition, that's a revolution from the concept of a database to the concept of a data space. I think it would also be very interesting to link all of this to, so that's the next step of interoperability. So I don't give you the data, I give you the information that I want you to have. So it's, so I think there's very interesting issues also from the technology. Thank you.
In Italian now because it's the Italian atmosphere, but indeed it has been said, and we are definitely in a huge transformation. And what you are saying is that we are going forward and we might not go back. So we might not be able to go back, and we will
like it or not. The old times are something that we are not going to.
Absolutely. And when we share data, then we could be really in trouble if we want this data back. I don't know how many people here have tried to resign from Facebook, for example, but this is an example of what is coming now, and the huge challenges that we have, because indeed we are coming now. We are changing, we're transforming all our systems, and it's definitely a challenge, and especially at the national level, because indeed our colleagues who are representing now the national experiences will share their insights also, and the challenges they face between the European level, everything which is expected from them, and also you cannot hear us.
Yes, I can hear you perfectly. I just wish to very quickly react to what has been said about that need to move towards let's say, a lack of confidence, a lack of trust. And I would just encourage the professor indeed to take a look at the AI Act, because it seems to me that for high-risk activities, precisely the precautionary protocols that we have there mean or can be understood as a switch of paradigm, a change of paradigm. The premise now will be the lack of trust, and it involves a lot of monitoring. So precisely that act seems to me to create big hurdles if we take it seriously for high risk activities, in particular justice. Thank you. Sorry if I interrupted you, but I just wished to make the point.
Was not discussing this.
Yes. Indeed,
Sorry?
indeed. No, but Luigi was reacting. You want to say something?
Yeah, there's plenty of documents about these things. I didn't say that, this is new and it comes out of the blue and nobody's been thinking about this issue. Of course, there's plenty of people thinking about these issues. There's already documents out there. There's initiatives. I mentioned it, the Gaia X as an example for the thing. So I was just saying that it had not been mentioned in this during this discussion. I'm well aware.
You are absolutely right to mention it, and there is an urgency to take that into account now, and to take it seriously, and to stop being naive about all that. Stop being naive, and devil will be in the details, of course. If we say legal research, we are all lawyers around the table. We say legal research is non-sensitive. In my view, it's a mistake, because legal research, we say legal research is non-sensitive, and arbitration of and fine-tuning of and balancing of interests at stake is human and is only for the judge. It's a mistake, because if you have an erroneous legal pattern or legal analysis and legal research, your balancing of interest will be biased. So devil will be in the details when deciphering the consequences of all that for our judicial activities, it seems to me. And I can only concur and agree with what has just been said by the professor about the need to be more careful than we are in this respect.
So
That's the reaction.
Yes, Rosario?
That's the reaction to the principle set by region on the nature and of the elements used in the artificial intelligence. Because as this morning was said, this regulation, the European regulation on artificial intelligence, is a regulation on the market, is a regulation to create a fair, a free market for developers and manufacturers on artificial intelligence. And this is the reason that the national system, the member state that can regulate the principle on the use of artificial intelligence by users, by legal practitioners, and public bodies. I attend to the national body for the check of foreign direct investment in Italy, and we are very aware on the investment of foreign state, of extra European state in Italy and in the other European state in artificial intelligence and in sensitive technologies. And the principle is that we can't close completely the market. For instance, for the 5G communication technology, the principle is to moderate the number percentage of use of technologies, but we can't close. And this is the reason why I said that it is crucial for internal users to know how artificial intelligence works and to know deeply law and jurisprudence, because it's the only mean to check the acceptability and the reasonability of the output of this technology, because this technology is based on the principle of the black box, so you can know how it works, how it produces the single output. You can control the origin of the technology, the member of the manufacturer, the Asian or American manufacturers, but you can check the proper exactly how it works. You can check the result if it is acceptable and reasonable.
Thank you. Yes, indeed. This is now we are talking a little bit more about AI, while the challenge is broader than that. Indeed, AI is very specific. You are right, and with these threats which has already been taken into account in the AI Act, but it's also a broader challenge at the national level, and this is why I would like now to switch to the national level experience and ask our colleagues to share with us which is the level of digitalization in their countries, and also if they have good practices, what they have experienced with this digitalization process. The first one we would like to hear is Gianluca Gresso, but Gianluca is online. also a judge at the Court of Cassation now, but previously he was at the board of the FSM, the Italian school. Gianluca, as you are online, and we don't know if some AI is spying us, so I will ask you to be very, very short and not to share any sensitive information, and to be short also, because then you will be followed by our two colleagues, two ladies, to also compare the experience with the Italian one. So maybe in a nutshell, Gianluca, you could share with us the Italian insights at the national level on this digitalization process, AI, but also broader than that, the digitalization of the cross-border cooperation, for example, and the digitalization package as well. So, Gianluca,
yes.
how is the situation in Italy? Basically,
the situation is on. You can hear me, yes.
yes,
right.
we can hear you.
I think that today you have heard something about the situation in Italy. It's ongoing. We have a process that is in a certain way in civil matter. It's a long story that started in the 80s. And also I think in this moment, in every degree of judgment, we have a fully digitalization. Even now, by 1 year inside the Court of Cassation, everything is digitalized in civil matter, because a criminal topic is less advanced, because there are more problem related to privacy, data protection, and link interoperability with police and other legal forces. So it's more complex, the world of criminal justice. But in civil justice, we are in very high point, and all the activity done by the civil judge, also writing a judgment, is done only by computer and in connection with the system that allow us to deliver the judgment and to sign also the judgment only digitally. So it's totally paperless. Also in Court of Cassation, in criminal matter, the things are going on. But the judgment is still written by paper and delivered and then scanned. So the thing is a lower point. I had just, I don't know, Ingrid, because there are several projects. I think you have talked about it this morning. About the ongoing digitalization. Of course, the situation in Italy is strongly related to what is going on, not only at European Union level, but also at the level of countries of Europe. For instance, there is a great work done by the working group by CEPEJ on cyber justice and artificial intelligence, which delivered several documents. And I send you the slides now. The time is consuming and it's not possible to do the presentation, but it's very interesting because it compares what are the pros and cons about in a very concrete way about the possibility. But I would like just to underline a point that has been said before among the others, the fact that training is also in this field is fundamental, and we train not so much, but we need to do more and more, because the higher risk is the loss of the ability to carry out judicial activities. This is the worst risk. Just to have judges that no longer are able to control what the software AI is doing. So even if we prohibit by law, not by regulation, decision making towards AI, we are in fact slowly realizing it, because if we don't maintain a level of control, we will not be able to correct, no, to say something different to what is proposed by software, by AI. That's the worst risk that we are incurring it. That's more or less, Ingrid. Thank you.
Thank you. Thank you very much, Gianluca, also for reminding that there is need for more judicial training. And here, as you mentioned the situation in Italy, I would like to hear from Cristina Becavac, who is the director of the Judicial Academy in Croatia, how the situation is in Croatia, and which challenges at the national level, also opportunities and maybe best practices or good experience you have to share with us to feed the reflection on how we can tackle the challenge with judicial training. So Cristina, could you please take the floor and share with us your insights?
Thank you, Ingrid. Good afternoon to everyone. First of all, I would like to express my sincere gratitude to Ingrid for inviting me to take part in this discussion on the European Digital Decade. The Judicial Academy of Croatia has been a long-term proud member of HATN and has been a part of HATN working group Digitalization since its beginning. From its very beginning, the Judicial Academy has been keeping up with trends in the digitalization of judicial training, and is currently effecting a new method of training application using a new platform integrated with Moodle. Its full implementation is expected by the beginning of the next year, and our new platform enables users to apply to training courses, access training materials, evaluate the training, and download their certificate of attendance. I would like to point out that it is not only the Judicial Academy undergoing the processes of digitalization, but our judiciary as a whole. This process is being piloted by the Ministry of Justice, Public Administration and Digital Transformation in Croatia. Although the implementation started before COVID-19 pandemic, it has picked up since. Today, there are a number of e-services provided by the government platform called e-Citizen. E-Citizen is the central point for all public sector information and services in Croatia. The platform is available to all Croatian citizens who can access it using a variety of credentials. E-services provided through the domain of Ministry of Justice, Public Administration and Digital Transformation includes e-communication, e-bulletin board, e-case, e-enforcement, certificate of no criminal proceedings, real estate registration and cadastral joint information system, the insolvency register, criminal records, and the anonymization and publication of court decisions. E-case is unique IT system for the management of court acts, consisting of user-friendly software, application, computer and telecommunication equipment and infrastructure, system software and tools, and all the data entered, stored, and transmitted by this system. One of the main goals was to restore citizens' trust in the objectivity of the work of the courts, on the account of fair and random allocation of cases, rather than relying on the discretion on the President of Court. E-communication is another service widely used by lawyers, bankruptcy administrators, notaries, expert witnesses, court interpreters, liquidators, special guardians, trade union and employers association lawyers, as well as natural and legal persons who can submit and receive any case, specific files or documents, and remotely monitor their status of their cases. Since the COVID-19 pandemic in 2020, Croatian courts have started the practice of remote hearings in civil proceedings using the platform Microsoft Teams. In 2022, the practice of remote hearings was introduced in criminal proceedings as well. The practice includes the possibility of using an audio-video link during the indictment panel, preliminary hearing, and hearing of the victim of a criminal act. It is worth noting that there are a number of advantages of a remote hearing, like the possibility of organizing hearings regardless of the location of parties involved, saving on travel costs, and greatly contributing to the efficiency of the justice system. The new civil code in Croatia has introduced the possibility of audio recording of all court proceedings. Full implementation of audio recording is expected by May 2025 and will cover 1,317 courtrooms and 123 locations. Recording of the court proceedings will allow for increased transparency and faster availability of information, often not actual case. The authenticity and originality of the technical documents guarantee the authenticity and identity of the facts presented by the parties in proceedings, while at the same time relieving the court and court staff. It is worth noting that Croatian courts are faced with a severe lack of court staff, court reporters in particular, a problem that could be dealt with by full implementation of audio recording of court proceedings. AI is used when automatically transcripting audio recording of proceedings. The main challenge of transcription is use of dialect. Maybe it can be solved by learning a system to recognize that dialect. But there are a number of examples of positive changes brought about by the process of digitalization of the judiciary. Employment in public and state companies requires a number of specific documents such as certificate of non-conviction. All these documents had to be issued in a physical form. But today, this request can be made via e-citizen platform, and valid certificate with the digital signature will usually be issued within minutes of request. Another positive example of the digitalization of the justice system is that it has enabled judges and prosecutors, as well as other judicial officials, to remotely sign decisions and cases, reducing the need for actual physical presence. All these mentioned services, tools, and practices have greatly contributed to the efficiency and transparency of the justice system of Croatia. The Judicial Academy is proud to be a part of a process by helping its stakeholders, especially judges, prosecutors, and other judicial officials, to learn how to proficiently use all these available tools. So, maybe I can mention cooperation with EJTN, that we have an excellent cooperation with the network, and participants from Croatia are attending a large number of EJTN seminars and webinars on digitalization each year, on topics such as the cybercrime, use of digitalization in service of documents, and taking of evidence abroad, and etc. So thank you for providing us all the trainings that we need. I sincerely hope that this European Digital Decade will turn into a European Digital Century. And I'm proud that the Judicial Academy of Croatia can share in this future. Thank you for your attention. And we understand that in Croatia, digitalization is taken as an opportunity, definitely, and also the cooperation with the JTN is very good, because you are sharing a lot with the network. So thank you very much for that. And it's interesting to see that indeed you talked about the compensation of the lack of cold start, for example, with the recording, with the automatic recording. So this is a kind of AI as well, and we have been mentioned that. So with all the questions that are raised by this artificial intelligence, and how indeed we can use it as an opportunity, while at the same time also being trained and being aware of what it is, how it works, and then make sure that it is also transparent for the justice professionals and the citizens, the way we work with these new technologies. So this is definitely very interesting to see how at the national level this challenge is tackled, and to compare with other experiences, because now we have also France, represented by Emmanuel Lodic-Baron, who is representing the French National School for the Judiciary, and who will also be sharing the way the school is addressing digitalization in the trainings, to align with the digital transition of the French justice as well. So, Emmanuel, would you like to take the floor, please?
Thank you very much. Dear colleagues, today I will speak about the digital transition of the judicial system in France, but I wouldn't talk about everything, because we talked this morning, for example, of the Cour de Cassation, and I wouldn't go back on this topic. I want to focus on two major aspects of the digital transition. First of all, the implementation of what we call PPN, the Digital Criminal Procedure in France, and the new training challenges for legal professionals. This transformation, the PPN, initiated by the 2018-2022 French Justice Reform Act, not only changes the way criminal cases are managed, but also the skills required to perform our legal profession in the digital age. The PPN marks a decisive shift in how the judicial system handles criminal cases. Its goal is to digitize the entire process from investigation to the archiving of judicial decisions. Several innovative tools have been introduced. Online complaint systems. Today, victims can file complaints through a digital platform, track the progress of their case, and receive real-time updates. The Victim Support Platform, for example, offers personalized assistance throughout the judicial process. There are also tools for law enforcement. Digitalization has also simplified the work of law enforcement, particularly for minor offenses. Complaint management is automated, allowing cases to be processed more quickly and avoiding unnecessary travel between law enforcement forces and prosecutor office. PPN has been gradually rolled out in some jurisdictions and will be fully implemented across 160 courts by 2025. One of the most innovative aspects of this reform is the integration of AI-based tools such as Tristan and Epopee assist with document analysis and improve case management. For example, the criminal procedure monitoring system assigns a unique identifier to each case for transparent and efficient tracking of judicial steps. AI is a major asset for speeding up judicial procedures and improving decision-making accuracy, but it also raises challenges related to data security and ethics. And this is my second major aspect of this presentation, is that this digital transition concerns the training of legal professionals. And for me, it's more important because I'm part of the National School for the Judiciary. The new digital tools require the development of specific skills to ensure the full effectiveness of this digital